welcome back to Law, Liberty, and Logic. It is Jamie here, and as you can see here, we upped the ante with our intro there a little bit because with your subscription and your following along and your commenting, it inspires me to do more. And so the more y'all engage and join the channel and join the fun, the more I feel the love and want to create more content, create more videos. So thank you so much, everybody, for joining with me today. And make sure that if you haven't yet, if this has just come across your channel, that you like, subscribe, give it an upvote here, get that notification bell going. So that way you can see all the latest content I'm going to have coming out, talking about hot key legal issues in Florida and whatever else comes up along the way, especially because we're about law, liberty, and logic, combine those things. So today we do have a very special topic, as you've seen in the description. We're going to be talking about the Florida field sobriety test statute. So this is going to be talking specifically about Florida statute 316.1932. So this is kind of giving you that general idea of what the Florida field sobriety laws are as pertains to operating a motor vehicle. Now, of course, when it comes to these presentations, everything that we talk about here is for informational purposes only. This is for educational purposes. This is not an attorney-client relationship. So you need to make sure that if you have a specific issue that you have an interest in for yourself, that you seek a licensed attorney if you need legal assistance. But this is a great way to start off your education, give you some food for thought, and help yourself with the process of thinking about this. Hopefully you don't have a bad situation for yourself right now, with this. Hopefully you can avoid having problems by, being sober, but also avoiding any types of trouble out there on the road. But regardless, things happen. And so it's always good to be informed and to know your rights. So without further ado, now we're going to take a look at those basics. So there is a specific statute created under the State Uniform Traffic Control that governs intoxication tests pursuant to an arrest for driving under the influence, right? So when we're talking about this field sobriety situation, we're talking about people who are getting pulled over in their car, and then the officer is seeking to see if they are driving under the influence of substances, especially, of course, as is common in Florida, alcohol, but it can be other substances as well. So Florida Statute 316.1932 tests for alcohol, chemical substances, or controlled substances, implied consent, and refusal. So this is a section that's going to be important to understand, to know what's required or not required when driving a motor vehicle, and the consequences therefrom if you refuse the test. Because in Florida, when you get your driver's license and you drive on the roads, the government has a claim to getting your implied consent to certain things. And there's consequences there. So you got to really pay close attention to those issues. All right. So we're going to specifically go into the statute here. Florida Statute 316.1932(1)(a)(1), the implied consent portion of this. So a person who accepts the privilege extended by the laws of this state of operating a motor vehicle within the state is, by operating such vehicle, deemed to have given his or her consent to submit to an approved chemical test or physical test. And it's really important to note that the state considers driving a privilege. Now, I don't think it should be a privilege in terms of what the law ought to be, but they will treat it as such as opposed to it being a right. So it gets real tricky, if you try to say you have a right to drive with the government saying no, it's a privilege and we can force things on you. So you just gotta be realistic about how they're going to treat it. So the legislature says that consent is deemed to be given, right? So the implied consent here is that by driving, and being in your motor vehicle, being on the roads out here, your consent is implied that you agree to these things. Now, there should be things to challenge with that, I think, in terms of the reality of what implied consent means. I don't think that consent is implied without it being explicit, but that is what they say, and that is how the courts will act. So they're going to act as if these things operate, and you have to be understanding that is, currently the statutory law. So again, there may be reasons that it is not acceptable for fundamental rights, right? We want more liberty, but the statute stands, and the state of Florida will act. That is, the prosecutors or judges, they will act as if this is how it works and operates. So just understand that they are going to act in these premises. Okay, let's take a look here at the next slide. So, including but not limited to, now we're getting into the tests themselves, an infrared light test of his or her breath for the purpose of determining the alcoholic content of his or her blood or breath if the person is lawfully arrested for any offense allegedly committed while the person was driving or was in actual physical control of a motor vehicle while under the influence of alcoholic beverages. So, again, these are very narrow conditions, right? As always, when it comes to legal statutes, you have to make sure that you're following the predicate conditions and looking to see what all things have to be met before you get the applicable rule. So, lawfully arrested, right? Number one, right? If the person is lawfully arrested. So, at this point, if they're demanding a blood or breath test, they haven't arrested you first, right? So they're saying, hey, we have probable cause that you're under the influence. It says then after, for any offense, right? So any offense. So it could be, that they see you swerving in the road and you're driving recklessly. It could be, something else, but they are arresting you here potentially for something else or for being under the influence. Either way, if they suddenly see that, okay, it seems like this person is under the influence, they can breathalyze you. So it's really important to note that if you're driving and you're arrested for any offense allegedly committed while you're driving, while under the influence of alcoholic beverages, right? So there's also was an actual physical control of a motor vehicle. We won't get into all those different things because there's, different issues at play, whether someone was actually in control based on whether they were in the back seat and they had their keys and things like that. We're not going to get into all the nuances of that. But just for these purposes, in the generalities, you're driving, pull you over for some erratic behavior, probably. It's what's going to happen. Then they're like, you smell like alcohol. We're going to put you under arrest. Okay. Now we're demanding a breathalyzer, right? That's what we're really thinking about and looking at with this implied consent and what comes after. All right, let's take a look here at the next slide. So it says the chemical or physical breath test must be incidental to a lawful arrest and administered at the request of a law enforcement officer who has reasonable cause to believe such person was driving or was in actual physical control of the motor vehicle within the state while under the influence of alcoholic beverages. So again, there's more language to break down. Incidental to a lawful arrest, right? So this has to be that this is taking place at the incident of the arrest, the lawful arrest. Notice it says lawful, not unlawful. Notice that, incidental doesn't mean, we're going to test you 2 years later, right? So it's happening right there and then. And the law enforcement officer is the person who has to be administering, right? They're the ones who have to have that, administration. And then who has reasonable cause to believe that such person was driving or was in actual physical control of the motor vehicle. So it's the officer who has to have this knowledge as well. So important fact there that sometimes has come into play in certain key cases, but the officer is the one who has to have that cause, that knowledge for that cause, that reasonable cause. Has to be within the state, so it's not driving outside the state, within the state, and then while under the influence of alcoholic beverages, right? So key things, right? It's going to be officer arrests you, you're in this state, the officer's the one who has that reasonable cause, and they're saying, hey, you're under the influence of alcoholic beverages. We want to breathalyze you. Okay, so the administration of a breath test does not preclude the administration of other type of tests. So it's important to note that just because they do one of these types of tests, they could do others. And we're going to go through those different tests that they could potentially do to you. It's just a matter of different scales and different legal predicates that they have to think about. So this is an important part here, though, with the statute, with the implied consent in terms of laying it out. So we're going to take a look here at this specific language. So it says the person shall be told that his or her failure to submit to any lawful test of his or her breath will result in the suspension of the person's privilege to operate a motor vehicle for a period of 1 year for a first refusal or for a period of 18 months if the driving privilege of such person has been previously suspended or if he or she has previously been fined under section 327.3 5215 as a result of a refusal to submit to a test or test required under this chapter or chapter 327. It gets really long. And shall also be told that if he or she refuses to submit to a lawful test of his or her breath and his or her driving privilege has been previously suspended, or if he or she has previously been fined under section 327.35215 for a prior refusal to submit to a lawful test of his or her breath, urine, or blood as required under this chapter or chapter 327, he or she commits a misdemeanor of the first degree, punishable as provided in section 775.082, section 775.083, in addition to any other penalties provided by law. So that was a long-winded section, a long sentence. Need a drink of water after that one. So you can already see here that if you refuse this test that they're about to give you after you've been lawfully arrested pursuant to the officer having reasonable cause that you're driving a vehicle under the influence of alcoholic beverages, at that point you could be in trouble for a refusal. So if you have a first-time refusal, 1 year suspension of your driver's license. Right. So if you refuse the test and they met all those proper predicates, as police officer in the state, driving or constructive possession of vehicle, they see, smells, reasonable cause. Okay, I think you're under the influence of alcoholic beverages. I'm arresting you for your behavior. Hey, now you need to have a breathalyzer, and you say, no, I refuse. 1 year suspension, driver's license. 18 months, though, if previous suspension or previously fined for refusing a DUI post-arrest test. Misdemeanor the first degree as well for the prior suspension / fine for refusal. So many attorneys will, say different things depending on the situation, but a lot of times they're going to say, most commonly, that refusal, if you do so, it's a first-time thing. You would get like a hardship license, work hardship license to keep driving if necessary. But by default, if you refuse at that point, they are going to suspend your driver's license for sure. Of course, the reason why someone would say potentially to not blow is to not give any evidence that you were under the influence and to try to beat the charge potentially in court. Obviously the circumstances of that are going to depend on how bad of a situation you're in and, what kind of predicate led up to that. But it's wild out there. I mean, there's been some crazy stuff that's happened, everything from someone who blew a 0-0 and the police still claimed that they were under the influence, to someone blowing very lightly, but they thought, oh, I'll be fine. But, they had a swig of alcoholic mouthwash and it, alerts improperly, right? There's different things that can come up and then put you in those crosshairs. So I'm not going to get into all the willy-nilly of what to do. I'm just here to just suggest that, if you do this and you understand the statutes, that there are consequences for that, just because if you drive and meet all that and you refuse, then, you're going to be facing that 1 year suspension of driver's license by default. All right. So the refusal to submit to a chemical or physical breath test upon the request of a law enforcement officer as provided in this section is admissible into evidence in any criminal proceeding. So it's important to note that the statute says specifically, if you refuse, they can mention that at the criminal proceeding. They can say, hey, he refused. So the reason why is because someone might be like, oh, I have a Fifth Amendment right to not incriminate myself. And, I want to say I refuse, or I don't want to speak or I want to remain silent, whatever. But in this case, they say that the refusal specifically to say, hey, no, I don't want to do the breath test could be admissible. Again, it's just something to think about in the totality of the factors, but that is what comes into play. You can refuse it, but there will be technically legal consequences for refusing the test at that point. So there's a urine test as well option. So it's the urine test in 316.1932, 1A, 1B. Similar to the breath test, there is a provision here for the urine test. A person who accepts the privilege extended by the laws of this state of operating a motor vehicle within the state is, by operating such vehicle, deemed to have given his or her consent to submit to a urine test for the purposes of detecting the presence of chemical substances as set forth in section 877.111 or controlled substances if the person is lawfully arrested for any offense allegedly committed while the person was driving or was in actual physical control of the motor vehicle while under the influence of chemical substances or controlled substances. So again, there's going to be a certain set of circumstances where a urine test could be demanded and there could be consequences for not doing it. So you just have to remember, just like before, just shooting back here, right? You have to have that driving, in the state of Florida or, in constructive possession. And there has to be a lawful arrest, right? So those are the predicate circumstances, the basic ones. So that's once that happens, right? It's not you're not going to have a urine test by legal default by walking. So it's definitely with driving. Has to be with the police officer. So the urine test, just like the breath test, must be incidental to a lawful arrest and administered at a detention facility or any other facility, mobile or otherwise, which is equipped to administer such tests at the request of a law enforcement officer who has reasonable cause to believe that such person was driving or was in actual physical control of a motor vehicle within the state while under the influence of chemical substances or controlled substances. The urine test shall be administered at a detention facility or any other facility, mobile or otherwise, which is equipped to administer such tests in a reasonable manner that will ensure the accuracy of the specimen and maintain the privacy of the individual involved. So note here, obviously with the urine test, that's way more sensitive, right? The last thing you want is to be whipping it out and peeing into a cup in the middle of traffic. That is not exactly something that you'd want to be, doing, and it might be very embarrassing and be a huge invasion of privacy, to say the least. So the urine test is, being more sensitive, has to be done somewhere special, and it doesn't necessarily mean that it is, in some building that is, a fixed structure. They do have mobile or otherwise, because you can have a mobile facility potentially. So maybe they're doing some checkpoint thing and they have a mobile PP facility. It's possible. But as long as they have that where it maintains, your privacy, it's equipped to maintain, to administer the test, to make sure the specimen's accurate and the privacy, is met, then they'll, be able to do that. If they get lawfully arrested, they have that reasonable cause to believe that you were in control of a vehicle, or, basically, in this case, driving or actual physical control. Then their option, if they want to test for specifically chemical or controlled substances, they could demand a urine test. Now, can you refuse a urine test? Of course, you can refuse, but there will be special consequences because of the implied consent. So as you can see, the predicate conditions are, relatively similar between our breath test and our urine test. The major difference is that the urine test, because of special privacy issues, must be done at a detention facility or the facility that maintains privacy. And obviously here with the urine test, they're especially looking at influence of chemical or controlled substances. So, usually with the PP test, that's more so something they're looking for ingested drugs that are maybe harder drugs than alcohol. With alcohol, usually they smell it. They're going to do a breath test. But, it's possible they could detect that with the urine test, that is the alcohol stuff. But usually it's more common just to do the breath test for that. The urine test, they're looking more for harder drugs. So, but again, it's on the table. So if you fail to submit to that, you can refuse it, but there will be consequences technically. And the statute says the person shall be told that his or her failure to submit to any lawful test of his or her urine will result in the suspension of the person's privilege to operate a motor vehicle for a period of 1 year for the first refusal, or for a period of 18 months if the driving privilege of such person has been previously suspended or been previously fined, and so on and so forth. So this is, basically repeating the same language as before. If you refuse, a first timer, you're going to have a suspension for a year of that driver's license. Then could be longer if you've already had a past issue where either you've been previously suspended or you've been fined. Then it could be even more of a problem for you. And it could even have a misdemeanor of the first degree on top. So it's something that, is a serious thing, and you got to be careful about that, if you do refuse. But for certain people in certain circumstances, refusal is going to make more sense, especially if someone is definitely innocent, or if there's something that's a borderline case. A lot of times people will make that subjective calculation and they'll do the refusal, and then they'll fight it in court potentially, and they could win. It's a possibility. But in the meantime, you might have to have a hardship license until that is resolved. But just note, those are the consequences for that urine test failure to submit after lawful arrest, especially when driving, not in other context. All right. So there's also the most invasive, the blood test. This is 316.19321C. The third major test of implied consent is the blood test. A person who accepts the privilege extended by the laws of the state of operating a motor vehicle within the state is, by operating such vehicle, deemed to have given his or her consent to submit to approved blood test for the purpose of determining the alcoholic content of the blood, or a blood test for the purpose of determining the presence of chemical substances or controlled substances as provided in this section, if there is reasonable cause to believe the person was driving or in actual physical control of a motor vehicle while under the influence of alcoholic beverages or chemical or controlled substances, and the person appears for treatment at a hospital, clinic, or other medical facility, and the administration of a breath or urine test is impractical or impossible. So notice here, this is a whole different level, right? Blood test is the most invasive. It's literally piercing into your body. It's literally taking your blood out. So cops can't just willy-nilly do the blood test. It's not, this is a next level thing. And it even says at the bottom here, of the statute, that the breath or urine test is impractical or impossible, right? So this is something that's a last rung situation. It's not a first tier situation. That's the blood test is hey, we can't get the breath, we can't get the pee. Okay, well, if they're appearing at a hospital, clinic, or the medical facility, they might be able to go with a blood test. So, it is concerning. And sometimes, it's difficult, to even do anything about that, especially if you're unconscious. So it says the blood test being the most invasive here, again, reiterating the predicates, requires the person appears for treatment at a hospital, clinic, or other medical facility, and the administration of a breath urine test is impractical or impossible. So again, the blood test only comes into play under limited circumstances where the breath or urine test is impractical or impossible. And where this usually happens is when someone is knocked out unconscious from an accident, right? So that's usually where you're going to see this. Someone's in an accident, looks like they may have been under the influence. They're unconscious in the hospital. The police do the blood test while they're unconscious. Very, scary thing because it's, it's done without your direct consent. So it's a big deal. And then you obviously wouldn't be able to refuse that if you're unconscious. So at least you wouldn't be able to counter it. So as used in this paragraph, the term other medical facility includes an ambulance or other medical emergency vehicle. The blood test shall be performed in a reasonable manner. A person who is incapable of refusal by reason of consciousness or other mental or physical condition is deemed not to have withdrawn his or her consent to such test. So notice that this here can be performed in vehicles, right? So it has to be something that is an ambulance or a medical emergency vehicle. This can't just be like, we're going to pull your blood in the back of, this pickup truck. It's, it has to be a specific medically oriented vehicle. But even if you're unconscious, they say it in such backhand language, but they say your being unconscious doesn't count as withdrawing your consent. So in other words, if you're unconscious, too bad, so sad, they're going to draw your blood if they have all those predicate conditions that you were driving. It seems like as if you were under the influence, lawfully arresting you because it seems like you caused an accident, probably, or your car, went some smashed way and it looks, like as if something happened that was caused by one's own reckless behavior, then they're going to potentially try to draw your blood if you're unconscious. So kind of scary that they have that consent implied to that degree, but they did write that way. So a blood test may be administered whether or not the person is told that his or her failure to submit to such a blood test will result in the suspension of the person's privilege to operate a motor vehicle upon the public highways of the state, and that a refusal to submit to a lawful test of his or her blood, if his or her driving privilege has been previously suspended for refusal to submit to a lawful test of his or her breath, urine, or blood, is a misdemeanor. So they're emphasizing in this blood test section that because it can be done to you when you're unconscious, the refusal statement warning is not required to be read. So that's an interesting note, that with the breath test, with the urine test, there's an argument there that if an officer doesn't warn you beforehand, then maybe something was wrong potentially with their, administering those tests, or how it came to be that you had those tests. But with the blood test, if they're at that level, doesn't matter. They don't have to give you any warning. Even if you're unconscious, they can basically, take your blood, and that's that. And that's kind of what they designed, is that basically in those situations where they can't get your breath or blood for whatever reason, because you're unconscious, well, they just go in there and take it. So that's one of those ones where it's, there's not much you can do in that situation, in terms of the actual act, because obviously you're incapacitated. So, and at that point, you basically not able to say no. So a person who is capable of refusal shall be told that his or her failure to submit to such, a person who is capable of refusal shall be told that his or her failure to submit to such a blood test will result in the suspension of the person's privilege to operate a motor vehicle for a period of 1 year for first refusal, or like before, 18 months if the driving privilege of the person has been suspended previously, or if he or she has previously been fined under Section 327.35215 as a result of refusal to submit to a test or tests required under this chapter, or Chapter 327. So same thing as with the breath and urine test, the consequences for conscious refusal are the same, including admissibility in court. So if you refuse, there's consequences, and they could bring that into court that you refused. So what about the flip side of things? What if the officer doesn't test, but you want it? Well, if the arresting officer does not request a chemical or physical breath test of the person arrested for any offense allegedly committed while the person was driving or was in actual physical control of the motor vehicle, while under the influence of alcoholic beverages or controlled substances, such person may request the arresting officer to have a chemical or physical test made of the arrested person's breath, or a test of the urine or blood for the purpose of determining the alcoholic content of the person's blood or breath, or the presence of chemical substances or controlled substances. And if so requested, the arresting officer shall have the test performed. So this is another interesting flip side to things, right? Maybe it's possible officer wants to arrest you for being under the influence, but you're sober. Maybe you had a condition that was a side effect of a prescribed drug or something. Maybe you have a medical anomaly issue where you have some type of dizziness or something, vertigo, whatever. And you're like, no, I'm sober. Test me. You can make that request. Especially if they're arresting you, the officer is going to have that test performed. They're supposed to. And if they don't, of course, there's going to be consequences in terms of evidence and issues that might come up. But you can flip it back. If for some reason you're in one of those rare and weird situations where you're like, no, I'm sober. What are you doing? Why are you arresting me? You can request that test. It's just that it has to be related to driving or actual physical control of the motor vehicle, that predicate, of course. And of course, they're saying that you are under the influence of one of these things. You just got to make that request. It happens, right? Someone has a medical event, right? It's not they had an accident or they swerved, not because of being under the influence, but because they, suddenly had some type of aneurysm thing or a heart attack thing or something, medically that causes them to have an accident or to roll off the road. It happens. And sometimes police officers will react to that and think that the person was, under the influence or something when they weren't. So there are times that you might be like, no, breathalyze me. I'm 0-0. I just had some heart thing and fainted, It's something to consider, if you're in that situation. So private testing is also another option. So in addition to requesting for testing from the officer, you could actually also, after these other predicate events have happened, request your own private testing because you're like, you know what? I don't trust y'all. I want my own, doctor to test me. I want something better, right? It's possible. So the person tested may, at his or her own expense, have a physician, registered nurse, other personnel authorized by a hospital to draw blood, or duly licensed clinical laboratory director, supervisor, technologist, or technician, or other person of his or her own choosing administer an independent test in addition to the test administered at the direction of the law enforcement officer for the purpose of determining the amount of alcohol in the person's blood or breath, or the presence of chemical substances or controlled substances at the time alleged, as shown by chemical analysis of his or her blood or urine, or by chemical or physical test of his or her breath. So important to note, you can request your own independent test as well, right? The officer can be like, we're breathalyzing you. Oh, well, you're 0.0, 8 or whatever. You can be like, well, no, I want a second test. You can request it. It's going to be at your own expense. So the law enforcement officer shall not interfere with the person's opportunity to obtain the independent test and shall provide the person with timely telephone access to secure the test, but the burden is on the person to arrange to secure the test at the person's own expense. So basically, if you request this, they're supposed to give you access to a phone line so you can call whoever you can, doctor, nurse, whoever medical person that you have a connection to, your best connection for doing whatever type of test. Who knows what your best connection might be for that, depending on who you are and how connected to a certain doctor you have on call or lab on call. But you can go ahead and get that done and try to do it as timely as possible. Obviously, the more time passes, then it becomes less credible potentially because as time goes on, the body processes it out. But obviously, with alcohol, it goes out a little faster. With hard drugs, that's like usually a little bit, more of an opportunity to test and see if this was in your system whatsoever. So it's just one more tool you have in the event of needing to fight something. So what about non-residents or any other person exempt from the driver's license law? Well, this is where it gets interesting. A non-resident or any other person driving in a status exempt from the requirements of the driver's license law by his or her act of driving in such exempt status is deemed to have expressed his or her consent to the provisions of this section. So in other words, these rules apply to everyone on the roads. So if you don't need a driver's license for whatever reason, or you're a non-resident, you're driving from Canada, those snowbirds, these rules apply to you. So it's going to happen to everybody who is out in the road. So they say that doesn't matter who you are, these rules, they're going to be on you no matter what. So there's something here that is an important thing to take away. And this is a big deal, a big delineation, right? Because while the Florida legislature made it clear that there's certain tests that, again, you drive your actual control, police officer arrests you, driving under the influence of some substance, they demand a breath test, this or that. Breath, blood, urine tests are not the same as field sobriety exercises that you might have seen on like TV shows, right? The common trope of someone walking in a straight line or doing some, special dance or something funny, that kind of thing. So there's this common misconception that drivers must submit to other exercises, right? Like you may have seen on TV shows where they have, a cop show where they have someone do a one-leg stand or walking in a straight line, toe over toe, or performing a horizontal gaze, a nystagmus test. But these tests are actually not required, right? The only thing that's required in terms of there's being consequences are the ones that are expressly laid out in the statutes. So you can refuse alternative exercises because they're not a part of the Florida statutes for implied consent. So if an officer says, hey, if you don't walk in a line and, dance on one foot for me, you know what I mean? I'm going to haul you off to jail. You could say, no, I don't consent to searches. I don't consent to this exercise. Let me know if I'm free to go now, that kind of thing. You don't have to consent to those exercises that are not required, and you don't have to go along with those for the sake of maintaining your driver's license status. Those other exercises that are, very commonly seen, especially in movies and shows that involve police situations and pullovers, those ones are not a part of the mandate that have consequences for your driver's license in terms of suspension or potential misdemeanor. It is just the breath, the urine, and the blood pursuant to a lawful arrest with an officer who has that reasonable cause for those, substances you being intoxicated while in control of vehicle, driving, that kind of thing. So again, if an officer tells you have to walk and turn for a field exercise or else your license is going to be suspended, they're wrong, right? Or they're saying it to try to get you to incriminate yourself, because maybe they don't have the evidence yet. Maybe they think that maybe you could be under the influence, but they're not really sure, but they just want to mess with you for a bit and see if you act extra weird, and maybe you trip over yourself, you trip over your shoelace, or whatever. They want to build a case against you potentially because they don't have it. You don't smell like alcohol, but they thought you were driving a little funny or something. Maybe you just had a slight swerve or something like that. Maybe you had a leg itch or something. Whatever it is, don't get tricked, right? Don't get tricked into consenting to do something that you don't have to do for the purposes of preserving your driver's license, right? It's a limited, narrow scope of things that officers can do, and it's only pursuant to that arrest, right? So you can always say that you refuse, you don't consent to searches, you don't wish to go along with any exercises, and then you can always say, am I being arrested? Okay, well, if I'm being arrested, and at that point, that's where you're going to make your critical decision about what it is you're going to do, whether you're going to, basically go along with the breath test or not. That is, you're going to be your own personal decision, and sometimes it depends on the circumstances, and different lawyers will say different things. But a lot of times they'll say, don't consent for the sake of fighting in court. But again, that's an individual thing. This is just for informational purposes only. So if you're in that situation, think through these basics. Make sure that, you're not giving in to more than what you need to do to legally comply for the sake of just, preserving your rights. The officers can only do what they have the power to do that is in the statutes. So make sure that those tests are done according, to what it is that, is to an arrest and what it is they have to follow, right? They can't just be like, hey, pee in this cup in the middle of the road, right? There's definitely things that if they don't do it right, they can be in trouble themselves. So be mindful of everything, be aware of your situations, be aware of what they're asking, say as little as possible. Just, obviously you just want to be as polite and respectful as possible, saying that, you just don't consent to searches and you wish to remain silent, and leave it at that, and, move on. But if you get arrested, then you have a whole different window of opportunities and choices. And you even have the ability to do things like request that you're tested if you were not, because you think the officer's doing something shady, or to get your own private testing to potentially challenge it as well. It's just, you have to think carefully, and of course consult your lawyer if you're making a call after an arrest kind of situation. So hopefully, that helps you kind of flesh through some of these basics. And, this presentation doesn't cover every aspect of the implied consent statute. It is a very big one. They give lots of details, even getting into some of the nitty gritties about, how they do testing and their blood tests and this or that and pee stuff. And there's, different cases and case law about people fighting over the edge of these cases. But the Florida statutes does give a pretty robust basic summary of what it is that the Florida government expects to be able to do with implied consent. And that is really because it was developed over many, many years of DUI cases and lawsuits and things like that. And eventually the Florida legislature just got to a point of being like, we're just going to make this very solid that, this is implied consent, and we can, do the breath, urine, and blood stuff, and the blood stuff, even if you're unconscious. They really wanted to make that clear, in light of cases where that was a contested issue with someone being unconscious. So now it's bright line, generally speaking, it's a bright line rule in terms of what it is that they're able to do when you are in, driving or, physical control of a vehicle in that situation. So it is way less murky than it maybe was 20, 30 years ago. But because of that, you can easily take a look at the Florida statutes yourself and read up further if you'd like, and get a sense of that. So I appreciate that you came and watched this video. And I am so thankful to everyone that continues to follow along, like and subscribe. So again, if you got to this presentation, Thank you so much for enjoying it with me. Please do make sure to give this a thumbs up, share it if you find it interesting. Let me know what you think in the comments. Make sure to get that subscription and notification going on. Hit the notification bell if you're new to this channel. This got service to you, because that encourages me, and then it makes me want to do more of these videos and cover more interesting things about Florida law, and that could be useful to you. And you're thinking about, okay, what's it like to deal with the law in Florida, and think about what it is that's going on, and how things kind of get edged out in cases and the statutes, over time. So I appreciate everybody, and I will talk to you very soon.